Ladies and gentlemen, we have a very packed courtroom, and I'm going to make an announcement and give my admonishment to those that are in the courtroom.
Welcome to another gripping session inside Judge Simpson's courtroom, where tension brews the moment he speaks. You can feel the authority in his tone as he reminds everyone that this is not a circus. A packed courtroom, restless spectators, and one clear warning. Any disruption will end with someone escorted out by deputies. This sets the mood instantly. Order, control, and zero tolerance. Today's docket is packed with personalities and drama, from defendants with bond violations to emotional pleas for mercy. Every case tells its own story, but Judge Simpson's composure is the anchor in this storm. He's not here to entertain. He's here to enforce the law, and you'll see that again and again as tempers flare and excuses fall flat. As we dive into People versus Luke Edwards, keep an eye on how quickly a case can turn from routine to chaotic. You'll see emotions, desperation, and the raw reality of courtroom justice. Who's right, who's reckless, and who's just out of second chances. Stay locked in.
There are some cases that people certainly are here to see and to witness what happens. However, I want to make it very clear that this court will not tolerate any disruption to these proceedings. If necessary, I will have you removed from the courtroom, and the deputies will escort you out of the courtroom. So I would ask that everybody that is in the courtroom, those that are outside of the courtroom, understand and govern themselves accordingly. Thank you.
If you want me to have them slap on my chair.
Let's get him done and then do it. Which one do you want me to do? They do. Okay, very good. Court calls the case of People versus Luke Edwards.
On behalf of the people.
Good morning, I'm Robert G. Cole on behalf of Mr. Edwards. Luke, would you state your name for the record? Luke? Can you hear me? Would you state your name for the record?
Jumbo. Jumbo.
Judge, just so I met with him yesterday for a significant amount of time. I finally got the competency report from the public defender's office, which also included a letter from the forensic center dated May 8th saying that the criminal responsibility had not been done yet, but they anticipate that. I don't believe that interview's been done. I spoke to my client yesterday about that. He was upset that we were going to court today, but I told him when we go to court today, because I don't have the criminal responsibility, I was going to ask for probably a 30-day adjournment in this matter.
Here's a glimpse of what many courtroom viewers miss. Competency evaluations. They sound procedural, but they're pivotal. Before any trial, the court must ensure the defendant understands what's happening. If a defendant isn't mentally fit to stand trial, the case pauses. Justice waits for stability. But look at the subtle conflict here. The defense wants a 30-day delay because the criminal responsibility report isn't ready. The defendant, Luke Edwards, is frustrated. From his side, it feels like endless waiting. From the court's view, it's ensuring fairness. This tug of war between legal patience and personal anxiety plays out daily across America's courtrooms. Judge Simpson's role here is to balance empathy with procedure. Should the court slow down to protect due process or move forward to maintain efficiency? What would you prefer if you were in Luke's position? Wait longer for accuracy or push ahead to get it over with?
You understand what you understand that, Mr. Edwards? I'll explain it to you once we go back there, okay? Okay?
You told me that yesterday, right?
Yes.
July 25th, 2024, 9 a.m. Bond will continue as denied.
Thank you, Your Honor.
All right. The individuals who were in the courtroom for this particular proceeding, you will leave the court as instructed by the officers. Those that are on the alleged victim's side will remain in the courtroom until such time as you are instructed you may leave.
Honor, we are asking to set this matter for examination today. It's also my understanding that there's been an allegation of a violation.
Yes, Your Honor, I'd like to address that appropriate.
You want this set for preliminary examination?
Yes, Your Honor.
What's the bond violation at this?
When he was in custody, he had called the victim over 24 times. He had requested a $50,000 bond on this case. The magistrate gave a 10% provision. He was released. I thought he was on a home confinement center with Kunke because he has a pending case up in circuit court where there's concealing firearm, a CCW. He's on height of probation. The thing that's concerning is not only he's contacting the victim, but the nature of the calls, the first original call after he was arraigned, the first thing out of his mouth is he calls her a bitch and says, "I'm going to beat your motherfucking ass." She says, "Hey, don't say that."
Huh?
And then there's another call where he's telling her to post his bond. And he says, "I'm going to slap the fuck out of you." What?
And there it is, the moment where the Bond story unravels. Judge Simpson's face says it all. Bond is built on trust, a deal that says, "We'll let you out if you play by the rules." But when someone uses their freedom to threaten the very person they're accused of harming, that trust disintegrates instantly. Calling a victim 24 times while out on bond isn't just a slip-up, it's a legal and moral disaster. The court granted leniency, and he turned it into intimidation. That's why prosecutors often argue for no bond, to prevent this exact abuse. Ask yourself, should freedom ever be conditional when threats like this surface? Or does every accused person deserve another shot, even after repeated violations? Judge Simpson is about to make a statement that leaves no room for confusion.
So I'm concerned. Not only these calls, he's calling the victim, violating his bond, but then the nature of the calls, what he's actually saying to her. After he's out, it's a gift.
He needs to be here. He'll have,
Understood.
I want him here at 1 o'clock today.
Understood, Your Honor. I just learned that these allegations are.
Sir, you need to report to the court at 1 o'clock today.
Thank you.
What court?
14A.
Where's y'all located at?
14A1. We're right by the
14.
sheriff's department.
Okay.
Right by the jail,
You
Mr. Harris.
Okay, report to court.
Court does call the case. People versus Jabari Harris. Yeah.
Good afternoon, Your Honor. Assistant Public Defender Jay Bellinger on behalf of Mr. Harris, whom I don't see here. I believe he's playing Pac-Man, Your Honor, and that he's ghosted us.
Okay. I don't even know what to do with that. I mean, I understand what you're telling me. I did order him to be here at 1 o'clock today, given the bench warrant will issue for defendant's failure to appear for this hearing, and given the allegations in the bond violation, bond will be set at this point at no bond.
Thank you, Your Honor.
Judges, the plenary exam is still set.
Pardon?
The plenary exam is not still set, correct?
I have not said it. I've not said anything.
Thank you. Thank you.
Bond will continue.
Your Honor, may I address bond?
Briefly.
Your Honor, Mr. Bailey was ordered to turn himself into the Washtenaw County Jail. He did so, I believe, approximately 12 to 13 hours later than he was ordered by Magistrate Fink. At this time, we would ask Your Honor to reconsider. I think a GPS tether would provide a guarantee of safety to the community, especially with the
Why didn't he turn himself in on time?
Well, Your Honor, I think he has ties to the community. The tether would keep everyone safe, and he's not able to.
I don't know that answers my question.
Could you repeat the question, please?
Why didn't he turn himself in on time?
He had childcare issues.
For 12 to 13 hours?
The courtroom exchange is short, but the tension is thick. The defense tries to humanize the delay. Childcare issues. Judge Simpson, unimpressed, repeats the same question. Why didn't he turn himself in on time? The silence says everything. Excuses might work in daily life, but in law, they carry no legal weight. Bond conditions are not suggestions. They are contracts between the court and the defendant. Miss a deadline, break a rule, or skip an appearance, and you break that trust. The judge's refusal to reduce bond isn't about cruelty. It's about accountability. This case illustrates how personal chaos collides with legal order. Everyone has a reason. The court deals only in results. Do you think the judge should have shown leniency here? Or does holding firm keep the system honest?
That's what he told me, Your Honor. I
Go
mean,
ahead.
he needs to find alternate childcare. It's not just,
Go ahead. Anything else?
no, Your Honor.
I don't need a response from people. Motion for bond reduction is denied. Bond will continue as it is. Thank you. Your name, ma'am?
Michelle Knoll.
All right.
Your Honor, we actually have come to a resolution in this matter. We had been waiting and our office had been told by the 14A sobriety court that they would not be able to evaluate Ms. Knoll for eligibility until Friday. They were able to get out yesterday to evaluate her and accepted her and had a plan. However, because of the information that we originally received yesterday, there's not a plea form available. And therefore, that's why she is very upset, because we will need to request an agreement. But we do have an agreement and a plan.
All right. So she's crying because she wants to get this done today.
I'm sorry.
Is that right?
I have something I'd like to speak on if you would allow me to.
Okay. Go ahead.
Thank you. I just want to thank you for letting me to speak on this matter. I just want to let you know that I did put myself in inpatient treatment after my setback with my bond violation. And I was in contact with community corrections to inform them that I was going to inpatient treatment in Bear River Health in Gaylord. And I completed treatment, and immediately after completing treatment, I turned myself in to Washington County Jail. And I have taken accountability, and I understand the seriousness of my setback, Your Honor. And I'm just requesting to be released under any conditions to handle my obligations and waiting sentencing and to enter sobriety court. I'm sincerely asking for your mercy and compassion, because part of my obligations is to be there for my mother in hospice care.
An emotional plea. The defendant's voice shakes, and for a moment the courtroom feels human again. Addiction, recovery, and remorse, they crash together in one heartfelt statement. She's not fighting the facts. She's appealing to mercy. Judge Simpson listens quietly, giving her full space to speak. And that matters. In law, acknowledgement is power. The system rarely offers sympathy, but when someone takes ownership, even a judge can reconsider approach and tone. Her words remind us that not every case is about defiance. Some are about redemption. But mercy in law has to walk a fine line. Show too much, and justice looks weak. Show too little, and humanity gets lost. What's your take? Should recovery earn leniency, or should past violations erase that chance?
And I have lots of support. It would help me with this, but as you know, hospice care is the end stage of life. But I am, however, looking forward to beginning sobriety court and continuing with my recovery plan in a new phase of my life. Thank you.
You're welcome. Okay, what we'll do is, if it's just a matter of getting the plea forms, everything else is in place. Today's what, 27th? So we'll put it out 5 days. I happen to have July 2nd. So we'll just put it out 5 days, get the forms in, then we can get it taken care of and try to get her moving on her way. Okay, fair enough?
Thank you.
July 2nd, 9 a.m. Bond continued. Thank you.
In addition, Mr. Tawfiq would like us to put on the record that he would like to submit a subpoena for a video from the VA, and we get on that.
A subpoena for video
For video footage pertaining to.
from the VA hospital?
Correct.
Okay. Well, I think that can be handled without the court's involvement.
Yes, we will,
Right.
we will handle that.
All right, bond will continue. Thank you, sir. You had something else?
Would it be okay if I say some shit? Would it be okay?
Pardon?
Would it be okay if I speak?
Oh, yeah, go ahead.
This is my sorry. This is my third time in court.
Yes, yes, sir.
It's my third time in court. Like with dealing with the VA. They sent me in jail for third time they sent me in jail. But they won't release any of the, like last time I was in front of Judge Perry, they went releasing any information for like a whole year and then doing the same thing again. And I'm afraid that I'm going back to jail. And I just, because they won't even release it. They won't give them all the prosecutor offers the information. They won't give them the full video footage.
Now, emotions spill over. The defendant isn't just talking, he's pleading. His words reveal fear, confusion, and deep mistrust. In his eyes, the system isn't protecting him. It's recycling him over and over. This is the dark side of legal limbo, where bureaucracy becomes a punishment of its own. Judge Simpson handles it carefully, cutting in only when necessary. He acknowledges the issue, then steers it back to process. Talk to your attorneys. It's his way of saying, feelings don't move cases, filings do. But this moment hits a nerve. It's the eternal clash between human frustration and legal restraint. To the viewers, do you think judges should intervene when government agencies stall evidence? Or does neutrality demand that they stay hands-off no matter how unjust it looks?
Do you think something exists that they may not be giving over to the prosecutor even?
Oh yeah, sir. I know a lot of it exists and they won't give it to the prosecuting office. And therefore I've been going through this for like 3 times now. Like they've taken me to jail. This is my 3rd time being in front of a judge and the 3rd judge. And it's an ongoing process. And like they're not gonna release anything.
Okay.
It just won't stop.
I think that's what your counsel was indicating, that what they're going to try to do is they're going to try to use the powers of the court that attorneys will have to try to subpoena some of that information so that they can get it. Okay, now that they're aware.
Is there any way if I can also get like some protection against them, like some type of protection myself against them?
Well, here's what I would do. I'm going to deny your request. I'm not going to deal with it. So what you would need to do is you would need to talk to your attorneys, deal with them, and let them sort of guide you as to what might be your best course. Okay? Sound good? All right. Thank you. All right. What are we doing?
Your Honor, we would ask you for an adjournment on this case to continue plea negotiations. And may I address bond?
Why, you want me to lock him up? No, go ahead.
No, thank you, Your Honor. So today, I understand there is a no-go-to order in place in a GPS tether on my client. I'm just asking you to consider removing the GPS tether. There has been no bond violations. The tether is really hurting his ankle. I won't go into the gruesome details, but causing him a lot of physical pain.
Another tension point: freedom with strings attached. The defense argues the tether is painful, even unnecessary. But from the prosecution's side, that small device is a line of defense for victims and witnesses. Judge Simpson must balance liberty and safety with each motion like this. Tether disputes sound minor until you realize what they represent: control versus trust. Every court condition is a test. When defense asks to remove the tether, the court hears, "Can we trust him unsupervised?" Judge Simpson's response is firm but methodical. No change until the alleged victim's concerns are heard. That's a textbook example of procedural fairness. He's not denying compassion. He's demanding caution. And think about this. Would you prioritize comfort or community safety? What if the tether was the only thing keeping someone from crossing the line again?
And my client has very little criminal history, so just a misdemeanor. I don't believe anyone was injured in the allegations here. So I understand the no-go-to order is still in place at this time, but we're just asking you to consider removing the tether.
Response from the people.
I'm just concerned that the defense counsel approached me today about changing the bond conditions so that he could go back to that area because he'd like to rent an apartment there. And so the victim had moved out. that they were no longer at the apartment, and I don't have any knowledge of that. So not knowing where the victim is and trying to change where, the tether is taking off, I'm concerned about that without talking to the victim, to be honest. This is a case where there's 2 counts of felonious assault. We had requested a $10,000 bond. They were given to get a $10,000 bond. Obviously posted it, but I'm concerned as to the victim's whereabouts, that they obviously know that she's not in the area anymore, and if you need to remove the tether, we don't have a good address for her right now.
May I have a brief rebuttal?
Yes.
Thank you, Your Honor. I don't think that there's been any allegations of my client trying to contact any complaining witnesses in this case. And again, I do understand, and he understands there would still be a no-go-to order in this case, which I think he can continue peacefully abiding by. It's just regarding the tether, Your Honor.
Well, I guess what you want is just a tether removed.
Yes, and we have no objection to a go-to order or a no-go-to order for wherever the complaining witnesses are residing at this time. In the future, we may ask to change the order, but not today.
Well, I'm not going to change that until they have an opportunity to have the alleged victim at least voice what concerns they may have regarding the removal of the tether. So I'm going to deny your motion for a change in bond condition. I'll set the probable cause for July 18th. Will that be enough time for you guys? 2024 at 9. So his bond will continue. If you're having problems with the tether, GPS tether, go over to community corrections if there's some problem with the fitting or whatever on it, okay? Yes, sir.
So when I first got it on, the tech said I had a weird shaped leg and she kept it super loose because she couldn't make it any tighter.
Here's a surprisingly human twist. The defendant claims the tether doesn't fit, even cutting his leg. It's one of those rare courtroom moments that border on absurd yet serious. Physical pain meets procedural rigidity. The judge doesn't mock it, though. He redirects calmly. Go to community corrections, have them fix it, and let the court know. This scene highlights Judge Simpson's strength, empathy without indulgence. He listens, but he doesn't let emotions dictate rulings. That measured tone keeps order and respect alive in a courtroom full of frustration. Legally, it's simple. If there's a genuine issue with equipment, the system adjusts. But the defendant's tone carries something deeper, fatigue, maybe even humiliation. It's a reminder that even small inconveniences feel massive when stacked on top of legal pressure. Would you interpret this as the judge being fair or dismissive? His calm might just be the only balance this courtroom needs.
The tech who installed it said I had a weird shaped leg. And so it's just banging around. I'm like, bloody.
So
and it's a scab.
it's like, okay, go over there and have them take a look at that. And if there's an issue, they will contact the court if there's a significant issue. All right.
Thank you, Your Honor.
Did you want to say something else? Or?
The first magistrate I spoke to, Fink, she said it wasn't on her. She told me I didn't need to have it, but somehow I had to have it to leave jail. Originally, when I spoke to her over the Zoom conference, said I didn't. There's no reason why we can't believe you can't abide by court orders. Those are her direct verbatim words.
She's the one that signed the tether order.
But she told me over the Zoom that I didn't need it.
I wasn't there. All right.
Thank you, Your Honor.
Thank you. All right, what are we doing?
Your Honor, I was just recently appointed on this, so I need to get the discovery and go over it with my client. So at this time, we're requesting an adjourned PCC date.
Conference, July 18th, 2024, 9 a.m. Bond continued.
Thank you so much, Your Honor. Have a great day.
You too.
Judge, you're not being very smiley today.
What?
I said you're not being very smiley today. There we go. There we go. Much better. I'd love to see it, Judge. Have a great day.
Yeah, I smile like that. That's scary. All right. Court stands in recess. Markowski People versus Amory Thrower. Oh, finally, she's going to get up and she gets to play. today. No, really. Thank you, Ms. Rosa. Because all day she's been sitting back there. The only reason Bellinger's even still afloat is because she's been helping behind the scenes. And now, oh well. Okay, maybe that was a bit harsh, but. Go ahead.
Good afternoon, Your Honor. Maisie Berger requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Attorney Jay Bellinger, representing Amory Thrower.
Are you reading that?
I almost have it memorized.
Hold it. Man, this has nothing to do with you. I got to deal with it. Why don't you have that memorized?
I'm not good with numbers.
You're what?
Not good with numbers. The 8.120, I get it messed up every time.
Oh, okay. But the rest of it you got.
Yes.
So you just had to have the 8.120.
Absolutely.
Okay, you got to just sort of lock that in.
Okay.
Before that happens.
8.120.
There you go. So the reason I think you had to read that is because Bellinger doesn't let you do enough cases. He gets up there and shows them himself. If he lets you do like, how many do you have today? You had like 8, 9, 10.
The boss all the time, though.
What? No, well, you don't send her up there on the ones that are kind of messed up.
I tried.
I know.
I just want you to have a good impression of me, not the cases that are hard.
What?
I want you to have a good impression of me.
I have a good impression of you.
Good. Oh,
It's
good.
him. No. No. Okay. That was my second cheap shot. I'm sorry.
I'm a punching bag for
Oh, now everybody feels bad.
Thank you, Jay.
Oh.
Seriously? That's the only person who's ever said that.
You're correct.
Well, I know. That's why everybody in the room was shocked. Permission to practice is granted.
Thank you, Your Honor.
Ma'am, this has nothing to do with you. You're good, okay?
We would like to set for exams today, pending a tentative resolution.
I don't know what that meant. You want to set it for exam?
Yes, we would like to set for exams today. Exam today.
Oh, okay. Is discovery complete?
Yes.
Yes, Your Honor.
Would the people have their witnesses available on the 9th?
We'll do our best.
Preliminary examination in person will be set July 9, 2024, 9 a.m. before Judge Burke. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, ma'am. She finally, I know you missed it. Bellinger finally let her get up and say something. I know. No.
And just like that, Judge Simpson ends the session. But what a ride it's been. We witnessed defendants begging for mercy, lawyers juggling damage control, and a judge walking the tightrope between empathy and enforcement. From bond violations to competency disputes, this courtroom exposed how justice is less about drama and more about discipline. Every case had a lesson. Accountability outweighs excuses, process over passion, and above all, respect for the court's authority. Judge Simpson's quiet authority shows why courtrooms are the ultimate test of human behavior. Some walked out free, others left with new dates, tighter rules, or no bond at all. But through it all, order held. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.